Good morning, everybody. My name is Emily O'Reilly. I'm the Ombudsman and Information Commissioner, and I will be chairing this particular session. I want to start, however, with a shameless plug for something that I am currently involved in, which is chairing the selection panel for the merged Irish Human Rights Commission and Equality Authority, which will be known as the Irish Human Rights and Equality Commission. I'm chairing that selection panel, and we have, a couple of weeks ago, we started placing ads looking for ordinary members of the Commission and for the Chief Commissioner, all of which will be designated posts until the legislation comes through, probably early in the new year. I would hope that all of you are aware of that competition by now. We have a dedicated website, which is ihrecpanel.com. We have a Twitter feed, which details you'll find on the site. We also have a Facebook page. And applications initially are being taken in through the public appointment service. That's publicjobs.ie. And if you want to make an application, you make it through there. But their sole role is to literally advertise and bring in the applications. And after that, it will be entirely up to the selection panel. Now, you may know that unlike the last time that certainly the Irish Human Rights Commission was put together, this time, the names that the panel will put forward will have to be accepted by government to go to for ratification by Parliament, and then a final appointment by the President. There won't be a whole smorgasbord of names drawn up to them, unless there are very extreme circumstances in why an individual could not be appointed, in which case they will have to talk to us and tell us why that is not the case. So really, the reason I'm taking this opportunity is because, first of all, I would hope that all of you in the organisations that you represent or that you mingle with would be aware of this, and that you would, if you're not thinking of applying yourselves for any of the positions, that you might talk to people that you think would make either excellent members or indeed Chief Commissioner. And particularly in relation to the Chief Commissioner role, the process that we're undergoing is very open, very transparent. People apply and that's it. There won't be taps on the shoulder, as it were. But I am somewhat concerned that people who may make fantastic candidates, particularly for the Chief Commissioner role, might not necessarily be aware that this is on, or might be a little hesitant to apply. So I would hope that all of you here, who, if anybody that you might have in mind, or indeed your good selves, somebody who might make a good Chief Commissioner, that you would approach them and encourage them to apply. And they can be from absolutely any area of Irish life whatsoever, as long as they did have, at the very least, a strong knowledge of in those human rights or equality, or indeed both areas. And I'd urge you to sort of let your mind wander in terms of somebody who is going to really understand the importance of the job, will be able to deal with the public administration, understand how the system works, and above all, that they will be able to merge the two bodies effectively together, that they get the culture right from the start, and that, most of all, that they will be effective. Okay, thus concludes my little piece on that. So I'd now like to introduce our first speaker this afternoon, and that is Duncan Wilson, who is Head of Strategy and Legal at the Scottish Human Rights Commission. And you can see there his fantastic academic and other human rights pedigree. And I think of most interest to us this afternoon is what he will be, or this morning, what he'll be talking to us about, that Scotland is currently developing a national action plan on human rights, something that has often been recommended to the Irish government. And he's going to talk on the national action plan to date. And he's also going to talk about something that is of particular interest to me as Ombudsman, trying to operate within a very straitened economic climate when certain things are not being done on the grounds that there's no money. He's going to talk about some of the work they pursued recently on human rights and public sector reform in terms of preventative spend, not cuts, and a framework for fairness and budget prioritisation. So Duncan, you're very welcome.
Thanks very much, Emily, and thank you to Colm, Roslyn, and everyone else at Amnesty Ireland for inviting me here. It's great to be here. I think, like many of the speakers today, I've passed through the amnesty system at one stage. So I'm speaking as someone who had a foot in the civil society camp, but now working with a national human rights institution. And I think both of those perspectives will to some extent inform what I'm saying today. The topic of my presentation builds on some of the themes that were raised by both Iain and Ignacio at the beginning of the day, and that is the mechanics, if you like, of taking a systematic, proactive approach to integrating human rights across law, policy, strategy, and informing more consistent rights-respecting outcomes. And in particular, as Emily said, I'll focus on the work that we are doing to lead or create an impetus for a process, a national process of developing a national action plan for human rights, which I know was recommended to Ireland in the Universal Periodic Review process, has been something the Irish Human Rights Commission and Irish civil society have been calling on for some time. And we had the glorious moment on the 30th of October this year where the BBC lunchtime news headline was in Scotland, Scotland is to have a national action plan for human rights, which I have to say, maybe a bit sad, but sent a little shiver down my spine of excitement. But now we have to deliver on that, and I'll explain a little bit about the process that we're developing to do that. So that's the structure of the talk today. It's pretty simple. Who, why, what, and how. The first part of that then, who am I? The Scottish Human Rights Commission is an independent national human rights institution in the way that your Irish Human Rights Commission has been. We were established by a statute of the Scottish Parliament. We have accreditation at the United Nations at A status, meaning we're independent. We have a broad mandate. Our commissioners have security of tenure. And we are effective, or is seen to be effective, and I'll try and explain some of the ways that we've tried to secure that perception. We currently chair the European group of national human rights institutions, succeeding your Irish Human Rights Commission in that role. And our mandate includes the broad range of promotion and protection activities that an NHRI should be able to undertake, free from governmental interference. We account to Parliament for how we spend public money. We don't account to government at all and have no institutional relationship directly in terms of management or oversight with any government department. The purpose of the Scottish Human Rights Commission, as was made clear in the parliamentary debates during its creation, was in broad terms, and this is a very ambitious agenda, to establish a human rights culture in Scotland, building on what was seen to be an inherent sense of fairness, and I'll come back to that word and what it might mean objectively, and whether it is indeed something that Scotland is delivering. There was seen to be an opportunity with a relatively new institutional framework in the devolution settlement, a fresh perspective that is keen to look broadly internationally, outwards, and progressive forwards to see how human rights can inform good public policy and consistent delivery, and a broad acceptance of human rights norms among the public in similar surveys to those that Colin mentioned this morning, to the value of human rights, empowering people to be active citizens. We have sought to deliver that by focusing on three pillars, really, and these are not new, but they're the central pillars of any human rights approach. Empowering people to know and claim their rights. We've worked with, as an independent mechanism, on the Disability Convention, which I know Ireland is yet to ratify, but that process is well underway. To raise awareness among disabled people's organisations of the importance and value of human rights, to the work that they are doing to look to secure or remove barriers to the realisation of their rights in practice. We have worked with public bodies to increase their ability to deliver human rights in practice. And we have looked to strengthen the systems of accountability, which Iain spent some time outlining this morning. A couple of examples of that work, just to sort of provide some other areas in which a human rights approach can be advanced in practice, which I think are relevant to just good public service generally, and are not excluded in times of economic austerity. But actually, I think the case is made even stronger by the need to ensure better, more effective service delivery in practice. One of the first pieces of work that we did was to evaluate the practice of a high security mental health institution in Scotland, the only such institution for Scotland and Northern Ireland, which had sought at the turn of the millennium to respond to negative publicity, a series of cases which had highlighted bad practice and indeed human rights deficiencies in the management systems, by proactively integrating a human rights approach in practice, auditing all policies, developing a participatory process to review everything that they did with patients, with staff, with carers, and with management, and moving away from blanket policies towards more individualized decision making. And we wanted to see, okay, what did they do? Did it work? And what were the outcomes? In terms of the outcomes, and I think that's what's most interesting today, some you would expect. So the use of extreme measures like seclusion and restraint, significant interference with human rights, went down dramatically. The tone of the institution changed, and staff, carers, management, and patients all told us the same thing. From an institution where you lost your rights at the door and regained privileges as a result of good behaviour, towards one in which was seen as a person-centred approach to care, a therapeutic environment in which individuals' rights were respected. These are the kinds of outcomes that you would expect from the adoption of a human rights approach. Some of those that I certainly hadn't anticipated were the benefits to staff, a happier workforce which felt a reduction in stress in a very tense environment where the staff were faced with patients who often raised their human rights as a threat. You can't do that, it's a breach of my human rights. And the staff didn't have the tools to be able to respond to that, to understand notions of proportionality, in terms of balancing risks and rights. So you have very tangible outcomes in terms of more effective public service delivery. The other main project under that ability strand that we developed ourselves was a huge capacity building program focused on social care for older people. The first thing we did when we were established was go around the country and ask people what should our priorities be, and the resounding answer was human dignity in the delivery of social care services, particularly for older and vulnerable people. I suspect a similar answer, amongst others, would be given in Ireland as well, and I know that has been a focus for the Human Rights Commission here too. In response, we developed a training capacity building programme which took the human rights standards and made them real in that context. And the messages were tailored to different audiences. So same messages, different approach for staff, for policy makers, for older people themselves in terms of empowerment, outreach, and for the decision makers themselves. And that training program then was evaluated. So what were the results there? Of course, people left knowing more about human rights than they knew when they arrived. But they also said that they felt more able to, again, balance risks and rights in making tough decisions about adult protection, protection of vulnerable adults, and the degree of intervention that was justified, but also to deliver more consistently person-centred care, which certainly in the Scottish context is the huge policy driver. With less resources available, you want to get more positive effect out of your resources. So you want to ensure that what you're doing is actually listening and informed by the people who are directly affected and delivers the kind of care and services that they need. And human rights also provides, of course, a legal and enforceable objective underpinning for those kinds of decisions. So it provides a legitimacy in making tough decisions. And that's a theme that I'll come back to again. This slide just outlines in a little bit more depth a sort of more practically applicable model of a human rights-based approach. 5 elements, and they're all equally important. Each of these can be traced to the international human rights standards. This isn't a law lecture, so I won't do that, but if there are any questions, we're more than happy to respond to them. Everyone has the right to take part in decisions that affect their lives, whether that is budgetary decisions at the local or the national level, or whether it's individual care decisions. Often you'll have a right to informed consent, certainly about medical interventions, but at least you'll have a right to politically participate in decisions that are going to affect your life. Accountability we'll come back to again, and it will be a theme, I think, throughout the day. Non-discrimination, you will all know, and the duty to prioritise the most vulnerable, which again the speakers this morning outlined. Empowerment is the untapped potential of a rights-based approach to transform a passive, apathetic citizenry into an active, democratically engaged, empowered population that recognises they have rights, and that public service delivery organisations have obligations, and that ability to then participate in decision making allows a sort of negotiation in the delivery of services rather than an opposition. And I think people often worry that accountability is somehow adversarial or oppositional, but I think a properly informed system of accountability can be constructive and can look at when things go wrong, why did they happen? What things in the system can be changed to stop that happening in the future, and actually consistently inform good practice. And crucially, of course, a rights-based approach is underpinned by the national and international legal framework. Okay, that's so much for the introduction, as it were. This is the sort of meat of what I wanted to talk about today. How to systematically address and integrate human rights across policy making. And a key element of that, it's not the silver bullet, but it does take in the broad range of public policy, is a national action plan for human rights. Recommended and agreed to by the world community in 1993, 20th anniversary next year of the Vienna Conference, World Conference on Human Rights. Is a great opportunity to mark that by a new wave of development of national human rights action plans, which are evidence-based, baseline assessment of where we are, where are the gaps and the good practices, participatory, based on that evidence, what should we be doing, what can we reasonably commit to given where we are in terms of resources, actually teasing out progressive realization in a process that involves civil society, public authorities in a negotiation, so that both sides recognize the aspirations and the pragmatic constraints of the other in a participatory dialogue and take some ownership of the outcomes rather than just feeling the effects. And crucially, it should be independently monitored according to indicators which themselves should be the process of participation. So the indicators have to be also part of that negotiation. This isn't our idea. Not only is it recommended at the UN, Council of Europe level, it's been tried and tested in a number of countries, and amongst those which we found the most useful to analyse and to learn from, New Zealand Human Rights Commission has been very helpful in sharing their experiences. And their baseline study, which was effectively a phone book in size with 500 recommendations, was in retrospect something that was maybe a little bit too detailed, and they encouraged us to open up that process of research to involve others so that there were no surprises and it was more likely to be implemented in practice. They did, though, evaluate the outcomes and showed that evidence of disproportionate use of restraint led to a negotiation on the development of guidelines on the use of restraint, and the outcome was a reduction in the use of restraint. Similarly, there with an inadequate child protection system leading to a change, quite a significant change in interagency collaboration around child protection. So concrete outcomes. So we followed that path, evidence gathering first of all, and this is in the broadest terms what we found. Scotland has a number of positive rights-based laws and a number of human rights institutions, including other regulatory bodies, taking a rights-based approach. We have some good examples of policy and strategy based on human rights, and outcomes, unfortunately, are inconsistent. Even where the laws and the policies are positive in human rights terms, the practice is inconsistent. So our challenge then is to transform good intentions into good practice more consistently. And what we have said is that this human rights action plan process can help assure and not assume that that good practice is happening in reality. At the top level, and here I'll draw some parallels, we have noted widespread ratification of the international treaties, very poor record in incorporating international treaties, only one, the European Convention on Human Rights, is incorporated. We have seen that the consequence of the limited sovereignty that the Scottish Parliament has, where it cannot do anything that is incompatible with human rights, has led to human rights directly infiltrating other areas of law. So our mental health law, our legal capacity law, which I know is something that you're looking at here, and others, start with a list of the human rights principles that inform the legislation. So we have good examples of good practice in human rights-based laws. But we also notice that the national standard, the Human Rights Act, is under threat, of course, at Westminster. And what we have is the opportunity, or it seems to be the reality, of two directions of travel on human rights, between the UK Parliament going backwards, historically looking inwards, and the Scottish Parliament and government being at least interested in looking forwards and looking outwards to practice elsewhere. So our Parliament, we don't have the notion of parliamentary supremacy. In the Scottish parliamentary context, we have a parliament with limited sovereignty. It's bound by human rights standards, at least the European Convention on Human Rights, but it also has obligations to implement the full range of human rights treaties. So separation of powers works slightly different in our context. But we don't have the mechanisms, the mechanics within Parliament that you might expect. There's no parliamentary committee on human rights which reviews bills as a matter of course, conducts inquiries in the way that the Joint Committee does in Westminster. There's no requirement for detailed memoranda explaining how a bill is human rights compliant. So that whole process lacks transparency, and there's a gap then in ability to contest or debate the best practice in human rights integration in our legislation. And we have used emergency powers far too often in the Parliament to enact human rights legislation. We're still too reactive, although we speak as though we're proactive. In reality, we had, for example, the European Committee on the Prevention of Torture visited Scotland in 1994 and told us that our practice of failing to allow suspects access to a solicitor and police questioning was a violation of the European Convention on Human Rights. In 2010, the Scottish Parliament enacted emergency legislation to address that gap. Now, what happened in the intervening 16 years was ignoring that fact and waiting and waiting and waiting to be pushed into a corner. So we're using emergency powers to fight fires when there's no actual emergency. For today's discussion, maybe this is one of the most interesting elements to it. We've heard today that there are two broad approaches to economic austerity in human rights terms. One is raising revenue, and the other is cutting expenditure. You might say that there's an opportunity to take a different course, to take a step back and say, how do we organise public service delivery in this new context? And the UK model, which is widely publicised, is reducing the size of the state, increasing localism, so-called big society, and a massive cut in public expenditure. The Scottish approach, driven by a commission which is headed by a former leader of a trade union, very well respected, and cross-party membership from the sort of great and the good, they recommended something else, which is public service reform. Looking at the way, at the high level, how do we organise our public services, and does it make sense? Can we be more efficient and effective by listening to people, the service users, by integrating services, by investing to save, the so-called preventive spend agenda that was mentioned before. And that whole agenda we have mapped to the human rights-based approach, and it maps out perfectly. There's a great opportunity there for us to look again at how we deliver the full range of public services and see how human rights can inform that process, and bring to that an objective, legally legitimate framework for making those kinds of decisions, for the prioritisation using the principles that Iain and Ignacio spoke about this morning. The red lines, the directives towards prioritisation, the principles on the process of decision making, and setting the direction of travel in terms of progressive realisation. It's all there in human rights law, but it's trapped in the minds of lawyers and not freed out into the public policy discourse, and that's what we're trying to foster. The second part here is that tools for proper decision making at the operational end. This is where human rights impact assessment is absolutely key, and we've been working with a range of public bodies, from the prisons to the health service to the government, etc., the broad range, to develop and now pilot human rights and equality impact assessment processes that are not tick boxes, that are actually informing a culture change within those bodies. It's early days, and I'm not going to overemphasize the outcomes, but there is momentum, there is interest. We have two local authorities who are piloting this across their work in the next budgetary cycle, and I would say watch this space. In 6 months, we'll have some lessons, and no doubt we'll make some changes, but there is a process of momentum there. So rather than cutting red tape, David Cameron's speech from last week, which I don't know whether it crossed over here, getting rid of these equality impact assessment and leaving it to, quote, the clever people in Whitehall, this approach is about informing proper decision making, and part of that is, and I'll say it again, listening to the people that are directly affected. There's a great example, I'm not sure if I've got the time, but very briefly from Coventry. Last year, impact assessment of all the cuts on women in Coventry started revolutionary by listening to the voices of women affected. And they heard that the individual cuts to child support, job seekers allowance, disability living allowance, in and of themselves might be marginal in human rights terms. But when you actually recognise that an unemployed woman who's a single mother to a disabled child is facing the cumulative impacts of all of those cuts, and consider whether that raises above the threshold of human rights abuse, that's when you start to think through the actual impact of numerous decisions on real people. I think I'll skip through this one because we've heard quite a lot about poverty and human rights response this morning. And this is just a quirk in a way that Scotland is positioning itself internationally as a leader on climate justice, thanks in no small part to Dr. Mary Robinson and her connection with our commission. Our chair used to work with her, so that's been very helpful. Which also leads to one of the other drivers in our context, which is a government which is very keen to be positioning itself as punching above its weight internationally. And the opportunity to link climate justice with a human rights-based approach with national action plans as a relatively cost-free way of getting international attention and positive recognition has been extremely helpful. Broader context, technological context, positives and negatives from human rights that you might expect. Any of this we can go into more in discussion. And I'm not going to speak to all these slides because I know you have them in your pack, but of course, as well as those big picture contexts, we looked at the policy framework. And some of this may or may not be similar in Ireland, but to say that we looked across the spheres of life from health and social care, the good practice, the grain with which we could build a human rights culture, and the gaps, the areas which we need to address as a society to be a rights-respecting country, social lives, justice, and security. Many of this may be similar here, but just to say a very obvious point, that the effects of the cuts, of course, or economic austerity, are felt not only in social rights, but human rights are indivisible. And I come to this as a human rights advocate, not an economic, social, and cultural rights advocate. And I see the connection, we see the connection in Scotland between cuts in legal aid, raising the threshold, as David Cameron is proposing, for the costs of judicial review, reducing access to justice, and the ability to challenge bad decisions that impact on your social rights. So there is no watertight division between the two. Final words, how. So those are all the facts, if you like, which can be contested, and we don't claim to have a monopoly on the truth. The next stage is asking two questions. Have we got it right? Are these indeed the gaps? Are these the areas of good practice? And then what should be done about it? And this is where the negotiation comes in. And on Human Rights Day, 10th of December this year, we'll be hosting a national human rights interaction where civil society, government, public bodies, academics will be led through a negotiation process where they can agree the 4 steps of a fair process for developing a human rights response. What are the facts? What is the rights analysis? Who is responsible and what should they be doing? And are they doing it? So it's a process and not an event, of course. A negotiation leads to the development of a national action plan, and the actors recall to see whether what was promised has actually been delivered and to understand why. And here, of course, one of the impetus perhaps that encourages our government and other actors that what they're doing is in international focus. Both Navi Pillay and Niels Muizhnieks, the UN and Council of Europe Human Rights Commissioners, have recorded video messages which will be delivered on the 10th of December event to sort of set the tone that what is happening in Scotland resonates internationally, and we're part of something global that is the realization of human rights and taking a human rights approach. Thank you very much for your time, and I look forward to the discussion.